I'm making an apology for lateness for member Paulwell. He'd been late, and he also asked if the minutes could be deferred based on him having some comments on it.
Sure.
To a later point in the meeting.
Not a problem, not a problem. So today we continue to go through the matrix as was agreed at the last meeting. And of course, there were some issues that were raised that we wanted some input from the OUR. So what I have decided subsequent to that meeting is to ask the secretary, Ms. McCarthy, to send off to OUR exactly what the clarifications and questions were, and get a response for them for the next meeting that we're going to have to conclude, hopefully. So we'll have that input either with them coming on or them sending something in return. But more than likely, it would probably be best to have them come on to do the clarification so that if we have any follow-up questions, we can just get it out of the way once and for all. The other thing is that some members were raising a question in terms of the process from the actual committee stage, obviously, right through to final approval of the amendments. So I got some clarification. So the decisions of the committee from the clause by clause review are compiled into a final report, which will include the amendments done by the Office of the Parliamentary Counsel, and that it will be sent to Parliament for debate and approval. Thereafter, the Ministry works with the OPC and other legal technical departments to finalize amendments to the Act, which is then taken to Cabinet for approval for Parliament to approve and debate and pass thereafter. So I just wanted to make sure that the members were very clear in terms of the process, in terms of how we get to the actual final approval of the act. So we will then, after this, get it to the point of where a report comes to us, and then we go through it again so that if there's any changes, we can make them there. And then thereafter, we move to OPC to finalize what we agree on. And then, of course, Cabinet, and then back to Parliament. So I hope that clarifies for everybody what the process is. It surely has for me, because I've chaired many joint select committees. So I hope that, so we will definitely defer the confirmation of the minutes until Member Paul will come based on his request. And then we can go straight into the continuation of the clause by clause review that Ms. Toller is going to lead us on. Any questions or clarifications before we move on? Okay. Thank you very much. Okay, so Ms. Toller, you have everything up on the screen now? Over to you.
Good morning, Chairman. Are you able to see the matrix?
Yes, I'm seeing. Is everybody else seeing?
Yes.
Okay, so we will begin at provision 6, standards of the single bio, and the recommendation here is from the Private Sector Organization of Jamaica. May enlarge it. And it says a new section 6.4 should be inserted to require that the published tariffs should be applied to other public utility providers based on aggregated electricity usage and not per metered service.
Okay, remember remember what we said in relation to if somebody has something, they will raise it. If not, silence is consent.
Yes, Minister. So another recommendation comes from the Jamaica Public Service Company, and this is in respect of section 6.4. And they're asking that the section seek to codify many of the international best practices to which the single buyer must adhere when proposing tariffs, and that the OUR should equally respect when setting them. It is essential that these principles should not be ambiguous or vague. The following are recommended. Rates should be cost reflective. Rates should be non-discriminatory. Rates should comply with all applicable rules, regulations, and/or licensees' license. Rates should not threaten the financial viability of the licensee, and rates shall be transparent in the sense that all choices of principles, policies, calculations, methodologies, and models used by the office shall be disclosed. So I will move on. So we move to part 3 of the Act, system planning, and provision 7, minister to be responsible for planning. And we have starred this recommendation as it is consistent with the umbrella national energy policy. The recommendation here comes from BMR Energy, and it says the following are proposed for section 7. In section 7.1, it is being recommended that clauses C and D should be expanded to provide for greater specificity regarding consultations. For consultations to be effective, they need to create a rigorous discourse with knowledgeable stakeholders and industry experts to inform decision-making. Stakeholders defined as electricity sector participants should be listed to include the independent power producers, as well as major affected energy user stakeholder groups, such as the Jamaica Manufacturers and Exporters Association, Jamaica Hoteliers and Tourists Association, Private Sector Association of Jamaica, and the Consumer Affairs Commission. I'll stop at that recommendation for the members to consider. Moving on to the,
Chairman,
go ahead.
Chairman, I suggest, and good morning, I suggest that other large scale users be the BPO association if they so desire. Large
Thank
scale
you.
users. Mm-hmm.
Thank you, member. Moving on to the next recommendation from BMR Energy. Also, it is recommended that all stakeholders are included in all communication and discussions prior to decision making. Moving on to the next recommendation, the BMR is recommending to revise section 7.2 to provide greater specificity about the inputs and assumptions of the planning process, specifically with respect to consideration given to priorities to support renewable generation resources, which by their very nature are located in areas with historically weak transmission access. Moving on to the next recommendation. This comes from WRB Energy, and again is in keeping with the umbrella policy. With respect to the enhancement of meaningful stakeholder engagement, it is suggested that section 7.1c and D be made more precise or prescriptive regarding consultations. For consultations to be effective, they need to provoke active and fact-based conversations with knowledgeable stakeholders and industry experts with the goal of providing a knowledge base for decision-making. Stakeholders should be clearly defined to include independent power producers, as well as major commercial sector representatives such as chambers of commerce, the hotel and tourism sector, as well as industrial participants representing large consumers. For this process to be effective, stakeholder input should be solicited with ample time to provide thoughtful responses prior to enacting changes.
Just a reminder for persons who are speaking to turn on the camera for the PBCJ.
The next recommendation comes from the Jamaica Public Service Company Limited. All the parties identified in section 7.1c, that is the OUR and other electricity sector participants, should have the obligation to comply with a request made by the minister in accordance with section 7.3 and not just a licensee. The planning process envisaged, my apologies, by section 7.1 requires an involvement of persons other than licensees, as the section speaks to electricity sector participants. Further, we believe that the imposition of an offense under section 7.3 should be removed. Well, let me stop for the first comment, and then I'll move on to the second portion of that comment regarding the offense. Okay, I'll move on to the second comment. We believe that the imposition of an offense under section 7.3 should be removed and that emphasis be placed on the planning process as consultative and not punitive. I'll move on now to provision 8. And this is part 4 under electricity licenses. The description is restrictions on certain electricity services without electricity license. The first recommendation by the OUR is at section 8.1b. It is recommended that the requirement for a license to erect, maintain, and have an electric line, etc., not be restricted to those used for supply of electricity only, but also include those used for transmission and distribution purposes as well. It is suggested that the purposes of transmission and distribution be added to the purpose of the supply of electricity at the end of section 8.1b. The next recommendation comes from Mr. Gerald Lindo. Again, this is consistent with the innovative nature of the energy policy. Rethinking self-generation is the title. He indicates that the matter of how person and exclusive use is defined is a critical one, which has some history. The language in section 8 reflects earlier language from the All Island Electricity License, which gave the utility the exclusive right to provide electricity service. And he quotes, provided that no firm or corporation of the government of Jamaica or person, emphasis in the original text in brackets, shall be prevented from providing a service for its or his own exclusive use. It is therefore recommended that the Joint Select Committee should be mindful of the ways in which the current law holds back innovation. He's asking that the Joint Select Committee consider whether it would be appropriate to change this dynamic by opening the category of self-generation to include cooperative ventures, or by the issuance of more licenses to supply electricity. And he goes on to say, in fairness to the utility, its role should be allowed to evolve towards a greater focus on systems control, interconnection services, transmission, and distribution. The future should be embraced rather than resisted. That's a comment from Mr. Lindo. Moving on to the recommendation from JPS. In section 8, it is proposed that section 8.2 be reworded so as to avoid confusion. As currently drafted, it allows a self-generator to engage in the activities under section 8.1 without the need to obtain a license from the minister. However, these activities include erecting, maintaining, or having any electric line or other works over, along, across, or under any street or public road for the purpose of the supply of electricity. These activities relate to the supply of electricity, considering that self-generators, by definition, only generate electricity for their exclusive use. It could not be intended that they would have the right to engage in the activities identified in section 8.1b. We therefore propose an amendment to this section which makes it clear that a self-generator is excluded from these activities.
Hello, Chairman.
Right. Who is that?
Hello.
Go ahead, we're hearing you. Identify yourself, please.
Yes, Anthony Hilton. I think this may be overbroad. The person generating may in fact need to establish their distribution. If you, first of all, I think it does not conceive of a single use, for example, a single use special economic zone, which could be of a significant size, depending on the level of investment. And therefore, that may need to go on the road or be an extension, a distribution line run to significant distances. So I think that is a very cramped view as to who could be generating and for what purposes, self-generating and for what purposes. I do not agree.
Noted. You noted that, Mr. Law?
Yes, yes, Minister.
Excuse me, Minister, so are we accepting or we're not accepting the proposal?
Member Hilton is objecting to that. We'll have to review that.
Okay, Minister.
The next section, section 9, described as a basis for grant of electricity licenses. And the recommendation here comes from the Office of Utilities. My apologies. Comes from the Office of Utilities Regulation. It is suggested that the following additional clauses be included in section 9.1. Pursuant to an application for a license in the prescribed form to transmit, distribute, dispatch, or supply electricity, or for the erection, maintenance, and having an electric line and works over, along, across, or under any street or public road. So the following clauses to be included. Additionally, pursuant to an application for generation of electricity from cogeneration facilities. And additionally, pursuant to the addition of new generation by way of a process approved by the Cabinet in exercise of its powers under Section 20. Moving on to the recommendation from JPS for Section 9. The Jamaica Public Service Company is recommending at Section 9.1c to set out the basis for the grant of electricity license by the Minister. Section 9.1ci and 9.1c1 and 3 identifies emergency situations which make a competitive bidding process impractical, exceptional circumstances, and financial conditions in the public's interest. Having regard to the importance of a competitive process, it is proposed that consideration should be given to include a requirement for the Cabinet to establish guidelines around what constitutes an emergency, exceptional circumstances, my apologies, and the public interest for the grant of a license under the section. This should enhance transparency where there is any departure from the normal established process. This could be done in a manner similar to the protocols and procedures by the generation procurement entity under Section 27 of the Act, Section 7.7 of the Act, and should be included as a schedule to the Act. Continuing under Section 9, basis for grant of electricity licenses, the next recommendation is from the Office of Utilities Regulation. As it relates to Section 9.3b, it is suggested that a detailed provision setting out a function of the regulator to review applications for electricity licenses, the matter to be considered, and submission of recommendations to the responsible minister akin to the provisions in the Telecommunications Act be included in the Electricity Act. And they have noted example sections 11 to 13 of the Telecommunications Act, which provide for the application for a license being made to the OUR. The provisions further set out the basis for the OUR's assessment of the application, including the fit and proper, legal, technical, and financial assessment of the licensee, and the matters for consideration by the OUR in determining whether or not to recommend the grant of the license by the responsible minister. Moving on to provision or section 10, characteristics of electricity licensees. The OUR is recommending that section 10.4 should be modified as follows. The minister may, after consultation with the office and considering its recommendations, include any restrictions or conditions, whether relating to the activities authorized by the electricity license, which appear to the minister to be necessary or expedient. A further recommendation at section 10.5, it is not clear why there is reference to payment of the processing fee in section 10.5A1 as a license condition when that fee should have been paid at the time of applying for a license as per section 9.4 of the Electricity Act. It is recommended that the words "and regulatory fees as may be determined by the office" should be added. Continuing, the OUR is recommending at section 10.8 that section 10.8 should not be restricted to generation licensees, but all licensees. It recommended that section 10.8 be deleted and a new provision be inserted at an appropriate location, which may read as follows. It is the duty of a licensee to ensure that the licensee does not commit an act or omission that will adversely affect, directly or indirectly, the security and stability of the system or the safety of the public. The next recommendation comes from Mr. Gerald Lindo. Creating a new category of license for energy storage. As more variable renewable energy generation becomes a part of Jamaica's energy system, more energy storage solutions must be brought on grid. None of these services fit neatly into the categories of licenses contemplated in Section 10 of the Electricity Act. The Act, thus, does not currently allow for these technologies to be deployed in an orderly way that gives equal opportunity to all investors. The Joint Select Committee should consider amending the law to include a new category of license for ancillary services that would allow for energy storage assets to be interconnected and leveraged by the system operator. This would allow for more innovation in energy projects, including in emerging electric vehicle-to-grid technologies to the benefit of the system operator and asset owners alike. The next recommendation is from the Private Sector Organization of Jamaica. In section 10.1, it is being proposed to amend item B by removing "as the case may be." And so item B is proposed as may be an exclusive or non-exclusive license for any or all of the following services, namely the transmission, distribution, supply, or dispatch of electricity for the entire Jamaica or any part thereof. Moving to section 11, register to be kept. The Private Sector Organization of Jamaica is recommending that section 11 should be amended to include such register shall be published on the ministry's website and shall be kept current by being updated at least annually.
Sorry, can you let in a member Green, please, to the meeting? Thanks.
Moving to section 12, restriction on transfer of electricity license. The Office of Utilities Regulation is recommending the prohibition on the transfer of license without the approval of the minister should also include similar restrictions on an assignment or transfer of control of the licensee. This will ensure that the government and regulator are not only aware of the ultimate owner and provider of the service, which may change over time, but they are given the opportunity to assess the suitability of such persons to have or control the license and licensed business. They go on to propose in section 12, it is suggested that detailed provisions like those in section 17 of the Telecommunications Act regarding the review and approval process for a transfer of license or transfer of control of a licensee be adopted, but that these provisions expressly require the assessment and recommendation of the OUR to inform the minister's decision to grant or deny such an application. Moving on to section 13, revocation or suspension on electricity license. I think the of should be removed there. This recommendation comes from the OUR. Section 13.1 should include a provision that the non-payment of regulatory fees and any other monies payable to the OUR would constitute grounds for the revocation of license. It is recommended that the following paragraph be added to section 13.1. Any fee payable to the office under the terms of its license or applicable legislation is unpaid 30 days after it has become due, and after the expiration of this 30-day period, it remains unpaid for a further period of 30 days after the office has given the licensee notice that the payment is overdue. A further comment from the OUR on section 13. Section 13.6, it should be an unresolved breach of the agreement between the licensee and the single buyer that should constitute a breach of the electricity license. These agreements usually make provision for the remedying of a breach. A contractual breach should therefore not automatically result in a breach of the license. Also see comments below on the proposed role of the OUR in resolving breaches. For section 13.6, it is suggested that the reference to a breach of that agreement be replaced with an unremedied breach of that agreement. Moving on to section 14, notification to the minister by the office. The recommendation comes from the OUR. It is proposed that section 14 should be reviewed. Perhaps the provision could be linked to the minister's powers of suspension and revocation of license in section 13. For example, the provision could be revised to require that the office should notify the minister of licensee actions or omissions that would trigger the powers of suspension or revocation and the processes under section 13, and the office should provide the minister with its recommendation for action in this regard. We continue to section 15, failure to comply with directions of the office. The OUR's recommendation in section 15 is suggesting that an express power of the regulator to investigate a licensee's conduct and its operations to ascertain whether it has contravened any of its obligations or whether the interest of the public is adequately protected, akin to such powers contemplated in the Office of the Utilities Regulations Act and Telecommunications Act, be included, and that the regulator is empowered to give directions in relation to its findings. Failure to comply with such directions constitute an offense. We had no comments on section 16, and so we move to section 17, duties of generation licensees or other self-generators. The OUR is recommending at section 7.2 that subsection 1 shall not apply to self-generators, only generation licensees. However, the identical provision exists at section 18.1, which deals specifically with self-generators. The inclusion of both sets of provisions, that is section 17.1 and 2, and section 18.1 seems superfluous. It is of note, they go on to say that.
Sorry to disturb.
Sorry.
The SG as your hand. Minister? Chair?
Go ahead.
Mrs. Alder has her hand raised, sir.
Go ahead, SG.
Okay, thank you. Morning, Chair, members, colleagues. My query is in relation to section 15. The proposal by the OUR is that there should be an offense. What type of offense? Right there says failure to comply with the directions would constitute an offense. Committee would need to, if the committee is agreeing to the proposal, the committee needs to determine what type of offense. Fine or imprisonment, or some other alternate sentencing option.
Chairman,
Go ahead, Member Hilton.
normally, in matters like these that are commercial, matters. The provision is not for criminal offense, not for imprisonment, but a fine. It could be a substantial fine, but I don't think we are, generally speaking, in the realm of imprisonment, except for the non-payment of the fine. There could be a custodial, provision. If the fine is not paid, then days in jail or months or whatever. But normally that's in the commercial realm, that's a fine, not imprisonment in the first instance.
Chairman, go ahead. Yeah, I note my colleagues' comment regarding the practice of the fine, of the penalty for corporate entities that are in breach. But my own recollection is that some time ago, one of the thinking was to hold some senior executive or executives of the company liable. And that was to mitigate against a company deliberately, knowingly involved in a breach. And because there's no personal consequences, they will take the financial risk. Therefore, the penalty does not become so much of a deterrent because it's the company and not the individual. So I'd like to put that on the table. My own personal thinking too is that every corporate entity must stop somewhere in terms of an individual, because the company is not, the actions are not abstractly done. They are done deliberately by individuals or the knowledge of persons who know or ought to know what the company is doing that would constitute a breach. The fine and the imprisonment is a provision that usually gives the judge the latitude in the circumstance to determine which prevails, whether it is both or either of the two. So I'd love to put that on the table for consideration.
Noted, Member Jackson. SG, you have any comment on that?
Just to point out that section 15 already, the fine, there is already a penalty. I was just trying to find the general penalty provision. So the fine right now is before a parish court, $5 million, because there is already a penalty for failing to comply with certain directions. It's just that the OER wanted to expand the remit of section 15. So it is possible that you could still use the same fine that is now attached to section 15, as well as go in a different direction, which is what Member Jackson is saying. But just to point out that the Interpretation Act, I think, would address Member Jackson's concern. Usually when there is a fine or when a body corporate commits an offense, the Interpretation Act says that the directors can also be held liable. So they don't necessarily just get away with it, so to speak.
But SG, I heard you, but there's a question. Even though the provision that you reference would make the directors liable, I think Member Ilton's point is whether or not, or rather suggesting that imprisonment should not be a penalty for corporate breach.
So if you'll allow me, I'll just tell you that section 53 of the Act currently says that an individual responsible for directing the affairs of a body corporate can be held liable as well and be subject to a term of imprisonment for a period not exceeding 2 years.
I would want that to continue through, Chairman.
Chairman, I have no difference of opinion there. My point was that generally that is not the case, but in specific instances, and I do agree that in specific intentional, knowing and intentional conduct, I believe can and should attract custodial sentences in the specific case. And as the member Jackson points out, the judge will have that latitude, so that to the extent that it is already a part of the overall scheme, I'm not seeking to reverse that.
Okay, thanks. So we would have just wanted the clarification. Thank you, Chair.
Noted, Mr. Tola, you have that?
Yes, Minister.
Perfect. Proceed.
So continuing with section 17, following the first recommendation, it is of note that although the marginal note indicates that the provisions of section 17 relate to the duties of generation licensees, but not self-generators, subsection 3 of that section expressly includes self-generators in its application. It is proposed that section 17 be reviewed. Perhaps the section can be made applicable to generation licensees and self-generators who hold a license, and then section 18.1 be deleted. The marginal note would have to be adjusted to reflect duties of generation licensees and licensed self-generators. Moving on to section 18, self-generators. And these observations and recommendations come from Jamaica Chamber of Commerce. In section 18, the self-generator is required to maintain an electricity system in accordance with the generation code. This is arguably not the standard to hold a household or commercial personal generator. There are other acts which confer standards and duties of care on these categories of generators. Note the fines for not adhering to the code on a self-generator is the same as that of a system independent producer. They go on to say, whilst wheeling by the self-generator, sorry, let me read that again. Whilst wheeling by the self-generator, it seems to be for an entity or by an entity, if it owns more than 50%, the Act forces the transmission and distribution of the same only by the single buyer. This contravenes the objective of competition and efficiency.
Could you only
The wording
50% of what?
It would be for the entity. It is that wheeling is allowed for an entity to wheel to another business if they own more than 50% of the share of that business.
Okay.
And so that is how the wheeling provision is defined. At section 18.1a, this recommendation comes from the OUR. Section 18.1a seems to require all self-generators, whether or not connected to the grid, to abide by the generation code, since there is no requirement for licensing or registration unless there is connection to the grid. It is not clear how this requirement will be enforced. They are recommending that Section 18.1 be deleted in its entirety and the provisions regarding the duties of a licensed self-generator be addressed in Section 17. The comment on this section from the private sector organization of Jamaica is at Section 18.6. It is being proposed to change the last line to read, an entity in which it or he has controlling interest. And the recommendation from the Jamaica Public Service Company is in Section 18.6, it is proposed to delete the words, and in the event that a market study conducted by the office determines the need for additional capacity, that self-generator may engage in wheeling to an entity in which it or he owns more than 50% interest from this section. Further comment comes from the OUR.
My comment on the section just read.
Okay.
With the inclusion of and the need for a market study, I think that
this week. No, this week.
Sorry, I think that undermines the nature of the self-generation provisions, because particularly the provisions above, if the right or the privilege is to be given to the self-generator in the ways that we have outlined previously, then if you're self-generating to an entity in which you have controlling interest or more than 50% as the case may be, then I don't think that we're talking about the need for a market study. The question is whether you're generating to self as defined in the Act. I do not believe the requirement for—
No, Mr. 99.99999%
for market studies is necessary. Was I heard on that, Ms. Keller?
Yes, Member Hilton.
Okay, all right. Thank you.
The continuing on with Section 18, the recommendation from the OUR is in regards to the use of the term supply in Section 18.2 is unclear on two grounds. The term supply already contemplates the sale of electricity, and therefore the use of sale and supply in the provision is superfluous. They indicate that supply should not be used in the context of self-generators because they are not permitted under the Act to sell electricity to consumers, which is a key component of the definition of supply in the Electricity Act. They may also generate electricity for their own use or sell it to the single buyer. they may only, my apologies, they may only generate electricity for their own use or sell it to the single buyer. Currently, under the net billing program, the sale of electricity from renewable sources is permitted subject to capacity limits of 10 kilowatts for residential customers and 100 kilowatts for commercial customers. Billing is only for energy supplied. At section 18.2, the OUR is indicating.
Mr. Chairman, if I may interrupt here, this is Auburn Hill.
Go ahead, Member Hill.
What I'd like to say here, Chairman, is I would like in the upcoming license that there are two caps, not just one cap that says 10 kilowatts for a household and 100 for a business, but annually there should be a cap of, let's say, 30, 40, 50 megawatts total. And I'm not sure that 10 shouldn't be 12 or 15. It should be reconsidered. That was said quite some time ago. And if we're going to grow the economy, we would expect businesses to grow, and we want them to grow with renewable. So maybe the 100 should be revisited as well. And therefore, an overall, so that we can say, it can't be said that we're going to affect the amount of power going on the grid for the utility. The utility has gone publicly saying that they want to add another 100 meter of renewables. Now, I believe because ordinary Jamaican taxpayers and citizens haven't had the full privilege that other countries have had, that of that 100 that the JPS has gone public with, so they can't argue that new renewable is going to affect them because they've gone public with it. We should say 50 megawatts of that should be for these private providers, the business people, the private people who have their homes, but especially business people who we want to grow the economy and grow it with renewable to make our place greener. So I think we should revise and look at these particular limits, the 10 and the 100, and then have an overall cap saying that an amount of so much can be done per year or whatever period of time. So we don't just have one limit that controls everybody. I'm submitting that for consideration.
Thank you, Member Hill. Anybody wants to follow?
Excuse me, Chair, from the recommendations for section 18.6, PSOJ proposed to add some words to the end, but JPS proposed the deletion of said words. So I'm not sure which it is that the committee has accepted for 18.6.
Pistola?
Yes, Minister. I'm showing the two sections, and the private sector organization has asked to change the last line to have an entity in which it or he has controlling interest in, while the JPS recommendation is to delete the words "and in the event that a market study conducted by the office determines the need for additional capacity, that self-generator may engage in wheeling to an entity in which it or he owns more than 50% interest." So theirs is a deletion, and the PSOJ is a addition.
Well,
if I may, Chairman, I prefer the PSOJ rendition. It's more market driven, and the JPS is once more a lot of control and not giving us enough room to let our electricity production increase without harming the grid and what else goes on, because constantly we see that JPS is holding, and that's natural, they're a business, is holding stuff as much as they can to themselves. And I have no problem with that. Businesses do that. We as policymakers and making policy or regulators must see beyond that. And I think the PSOJ suggestion is the direction we should be looking. Thanks a lot.
My previous comment, Chairman, was in support of the PSOJ's recommendation.
Chairman, I want to identify with that point made by Minister Hill on that matter.
Seems like we have consensus.
Correct.
Noted.
Noted, Chairman. So where I stopped was just after the discussion on net billing, following on for the OUR's recommendation at section 18.2. It says it should be reviewed, and language such as prior to entering into any arrangement for the sale of excess electricity, a self-generator shall. In section 18.2a, the reference to supply should also be reconsidered in light of the comments above regarding the definition of supply in the Electricity Act. It is also recommended that section 18.2a be reviewed, deletion of the words or supply be considered. Also, a reference to other energy supply agreements should be included. For example, enter into a standard offer contract or other electricity supply agreement as approved by the office with the single buyer or other licensee authorized to purchase electricity for such sale. And this is speaking to standard offer contracts for self-generators.
Chairman, again, first thing I notice is that there is no standard of performance required by the utility. No time. They can take 6 years or 6 months. It will never be 6 days. Nobody has that experience. So some kind of standard as to the efficiency and responsiveness of the utility must be included in this. And I come back to the whole point that, frankly, the utility is involved in doing what it does. It's also in the business itself. So I believe that maybe all this should not be done by the utility at all. It's a bigger question, but certainly if it's going to be done by the utility, clear performance standard and timeline must be given, because that's what is missing now. They take forever. You don't get it done. It's a year. What do you mean you need a year? You don't need a year to make a decision and somebody want to put some panels on their house. So it can be done quicker. So we must put some standard in this if we believe that the direction being considered here is the right one. That's the first, that's an a priori consideration.
Noted, member. Any comments on that? Proceed, Mr.
The Next comment from the OUR on the same self-generation section is at 18.3. This subsection should not be restricted to self-generators only, but to all licensees whose generating facilities comprise the merit order. Also, the provision does not take into consideration the provisions of the interconnection agreements and the codes, which would also allow the system operator to protect the grid and deny access to licensees. For section 18.3, it is proposed that a general provision be inserted at an appropriate section of the Act as follows. Except as provided for in the codes, licensees shall not be denied access to the system.
Chairman, I have one request to Ms. Tullow. When I study these things, I like to go through them. I wonder if it's possible to get an email with the pre and post and suggested and so on, as we see here, so I can mark it up, check with the Act, check with something else if I want to.
Ms. Mack?
Can we do that?
I don't see why not. Ms. McCarthy?
I'm just asking that Senator Hill just repeat what he just said, the request.
If you could email me what we're being shown on the screen so that I can take my time, because clearly as we go through this, there are lots of things I have to consider. I'd like to go through it, take my time, look at the Electricity Act, look at some other issues, and then when we come finally, or when we come back, I can then be sure that I've gone through it. I'm going to give you my email. I give it to everybody anyway. It doesn't matter.
Senator, I'm sorry, Senator. Just checking. Did you get a hard copy? I can email it, but I just want to.
No, I didn't get a hard copy.
Okay.
It is, Ms. McCarthy, let me put it this way. I have not seen a hard copy. And if it came to my office, I know Cadian would give it to me. So I want to be accurate.
I'll call you. Okay.
Okay. So you'll sort that out for me there. Thank you.
Yes.
The next comment from the OUR at section 18.4. The comments on earlier provisions of section 18 regarding the proposal to delete references to supply and include a reference to all licensees who are authorized to purchase electricity are applicable to subsection 4 as well. And at section 18.4, it is suggested that reference to sale or other supply of electricity be removed and replaced with a reference to sale of electricity, and the reference to single buyer either be replaced with supply licensees or the latter term added to the provision. For example, notwithstanding subsection 2, in circumstances where the requirements of subsection 2 are not met, the minister may, in writing, after consultation with the office and considering the office's recommendations, authorize the sale of electricity by a self-generator to the single buyer and a supply licensee pursuant to an agreement approved by the minister where he is satisfied that it is in the public interest to do. I think they mean so to do. Moving on to the next comment from the OUR. If this is acceptable, section 18.5 could be deleted. And now to comments at section 18.6, 7, and 9. As these clauses speak specifically to wheeling arrangements, it is suggested that they be pulled out and included in a discrete section on wheeling, or they remain as subclauses of section 18, but they be ordered as successive clauses with a side note indicating that they address wheeling.
Sounds
It is
good.
suggested, yes, I just go on to say, it is suggested that the reordering of section 18, 6, 7, and 9 be considered or placed in their own discrete section.
I prefer the discrete section properly labeled for wheeling, so it's easy to find when you're looking for it. So I'm agreeing with the last portion that you read there, Ms. Tulloh.
Thank you. Chairman, I see you.
Yeah.
Yes, you wanted to make an intervention?
No, go ahead.
Okay. All right, so there are no comments were received at section 19, independent power producers. So moving to section 20, procurement of new generation or generating capacity. The comment comes from the Jamaica Chamber of Commerce. In section 20, part 4, the act purports the concept of a single buyer, which reduces the opportunities for competition in sale of electricity and does not incentivize the single buyer to be efficient. The single buyer is afforded the first opportunity to replace its existing generating capacity as the Act gives it the right of first refusal, ROFA, an opportunity not afforded to any other generator on the system. This could lead eventually to the single buyer becoming the only generator, reducing the competitiveness of the entire generation to distribution of electricity process, thereby also reducing efficiency or disguising inefficiencies.
Mr. Chairman, the OUR couldn't have said it better.
Sorry, that was the Jamaica Chamber of Commerce.
Sorry, thank you, Ms.
Member
Tulloh.
Hill.
Well, thank you. So that's right. It does say Jamaica Chamber of Commerce. Couldn't have been said better. And that's something I would support strongly. We have a situation where if we don't watch out, we continue to perpetuate a monopoly that is, in my view, not in the best interest of Jamaica. In terms, we need a monopoly in transmission and distribution. I've said that over and over. So we're not talking about that. We're talking about when you are providing power, there must be competition among the providers. And that I get my chance to say again, we should probably then have the current owners separate out transmission and distribution into a separate SPV, special purpose vehicle, that is, among other things, open to Jamaican, lots more Jamaican shareholders by posting it on the Jamaica Stock Exchange. At least posting the company, the SPV, on the Jamaica Stock Exchange, and a portion of that amount being open to ordinary Jamaicans who can use their investment in this monopoly provider to help with their pensions when they get older.
Chairman, Member Hill's comments are apropos, although I believe that's just one aspect of the need for the transparency. It is also to ensure and to monitor that relationship, because in this way, in the way that is currently the case, the integration of the supplier, using this ROFA provision is really, I don't think, being appropriately monitored to ensure efficiencies and otherwise. The question of the merit order and who dispatches is also implicated in this whole discussion, and I believe we'll have a chance to go back to it. But I believe we need some greater transparency here.
Noted. I know Minister Member Hill has been very strong on this from day one. I mean, every forum he has got an opportunity to mention. He has raised this. So I'm happy that it is. I'm happy that it's widely accepted.
The next recommendation comes from the Office of Utilities Regulation at Section 20. It deals with scenarios for the addition of significant tranches of generation capacity. They say it may be tidied to include specific provisions that address the addition of capacity from generation facilities in this part of the Act. Section 18A merely mentions the power of the minister to prescribe the amount of capacity that can be added from these resources, but provides no detail as to the process by which such proposals may be assessed. It is recommended that the minister's power to prescribe the amount of capacity that can be added from cogeneration facilities be removed from Section 18 and moved to Section 20 or placed in its own discrete provision. Additionally, the cogeneration provisions should detail the process by which such generation will be added and proposals assessed. Consultation and consideration of the recommendations of the regulator should be included in the minister's determination of the cap and assessment of proposals for the addition of capacity. The next comment comes from BMR Energy. Recommendation at Section 23 and the third schedule. It is proposed that the right of first refusal provisions of the Electricity Act of 2015 be deleted to assure that all future generation capacity, whether it is for thermal, renewables, storage, or other technologies, be procured by the GPE through open, public, competitive bidding programs.
Again, through you, Chairman, that makes very good sense along the line what I've been saying. All power supplied should be done competitively so that you have fossil fuel. We're not going to get rid of fossil fuel immediately. And fossil fuel in its various forms. We hope less and less heavy fuel, but more and more gas possibly until we get to a lot more renewable, and different forms of renewables all must be able to compete and get rid of this ROFR, which I'm not going to judge history, may have served a purpose, but that purpose is now past, in my view. Thank you.
Chairman, to be clear, I mean, that view is broadly shared. I mean, whatever the reasons, the initial reasons for the ROFR, we have long since passed those exigencies and considerations of equity and fairness. Whatever those considerations were, I think we have now to look at a new era and a new period in our electricity systems and our electricity sector, because at this juncture, we have to be looking at what is most competitive and secure the economic future for the country.
Noted, Member Hilton.
I'll just add the BMR has put an alternative on the table as well, where they say failing in the removal of the right of first refusal provisions, it is proposed that the provisions are revised to 1, apply to all other generators with facilities procured through competitive bidding processes, and 2, require energy pricing offered to replacement projects be no higher than those that would be paid to projects of like type procured through competitive bidding processes. So just for completeness, to place their alternate proposal on the record.
Those two make sense. We can fuse them as we go along, but the overall outlook, as Member Hilton and I have just discussed, just makes sense. I think we can, and consistently, I think those of us who've been participating realize that ROFR has to go. So we find a better arrangement, and it has to be market-based, as BMR is suggesting here.
Agreed, Member Hill. That's also another issue that you have consistently raised in different forums. So I'm glad we're being able to deal with it in this forum.
Continuing at section 20, the Private Sector Organization of Jamaica is recommending that in section 20, subsection 3, the proposals for capacity replacement under ROFR should be amended to limit the single buyer from using ROFR for capacity replacement using cumulative of multiple smaller systems. A lower capacity qualifying for ROFR should be established at greater than 15 megawatts, and the single buyer should not be allowed to compete in residential or commercial markets. And so they go on to say at section 20, section 8, consider removing this section completely. Just find section.
I think just like the OUR recommended that wheeling should be separate. All the issues relating to ROFR should be combined in one section. And then the new arrangement that will emerge should go and replace those. Clearly, lots of people believe that ROFR is quite deficient, and many of us believe that it has served its purpose, whatever that was, and we must move on.
Moving on to the next recommendation, then WRB Energy. This is for section 20. We therefore recommended that the right of first refusal provisions of the Electricity Act be removed, and that all future generating capacity, whether it be for thermal, renewable, energy storage, or other generation, be procured by the GPE through open, public, competitive bidding programs. Failing the removal of the right of first refusal, it is recommended that the provisions be revised to require energy pricing offered to replacement projects be no higher than those that would be paid to projects of like type procured through competitive bidding processes. In the case where a competitive process is not feasible or practical, the pricing must be set via a proxy for a competitive process conducted by an independent third party with knowledge of the status of global power markets and future trends. The final recommendation in this section comes from Jamaica Public Service Company. They're recommending for section 20 that the act should be amended to establish the GPE as a legal entity, clearly setting out its powers and functions with respect to the procurement of additional generating capacity to the grid. Also, a complete framework should be done outlining the terms of reference, the term, tenure, technical competence, qualifications, and composition of the GPE to be included in page 18 of 26, or a schedule to the Act to allow for a transparent procurement process controlled by persons having the requisite technical competence. They go on to say the Act should also impose an obligation on GPE members and appointees to disclose conflicts of interest, including those arising by virtue of close family and business relationships. A precise mechanism to address real or potential conflicts of interest by members and appointees, including grounds for disqualification and removal, should also be included. The JPS has a further comment at section 20, subsection 7, to provide certainty in relation to the procurement process. It is being proposed that the rules and protocols to be developed should now be developed and included as a schedule to the Act, and must also benefit from the policy assessment carried out to enable the current review exercise. The rules and protocols, like the Act, should also benefit from periodic review to ensure that they are relevant and current. Furthermore, to support transparency, predictability, and orderly planning and development activities, JPS is recommending that the Act specify the time by which the notification letter is to be sent to allow for orderly planning and development activities. They recommend a minimum of 6 years prior to the scheduled retirement date of the asset. And the ministry, as part of the IRP process, they're asking should publish the methodology for the determination of the avoided cost of generation that will form the basis for the biannual update. They go on to, just to conclude that comment, the inclusion of a provision for the GPE to table a report to Parliament within a specified period, setting out the reasons for a capacity procurement decision. We'll continue with another comment from JPS on section 20. It is being proposed that section 20, subsection 5 be deleted, resulting in the exercise of the right of first refusal through a subsidiary under section 20, subsection 8. We are of the view that section 20, subsection 5 may lend itself to misinterpretation, and that section 20, subsection 8 adequately captures the intent of the section.
View is noted, but we have had enough discussion in this. We note it and move on. With your permission, Chairman. We've had
yes,
enough.
I'm just to indicate that there is another joint select at 2, so we're going to cut off at 12.
Yes, we have
time to refresh and get prepared for the next meeting. So we have 11:37, so we can continue to 12.
Chairman, the further comments from Jamaica Chamber of Commerce and the OUR are again on the ROFR. So do you want me to move now to section 21? or do you want me to go through them as well? There are two additional ROFR comments.
Let's have them. Let's have them on for complete.
Go ahead. Okay, thank you. So from the Jamaica Chamber of Commerce at section 25, they indicate it does not extend the ROFR to subsidiaries of the single buyer, given the semblance that subsidiaries would be treated similarly to other generators. Then section 20 at 8 permits the replacement through a subsidiary. This is a clear conflict which needs to be addressed by the Act. Does it mean that as an IPP, the subsidiary will then also have the ROFR while the other IPPs do not? The existence of a ROFR in the Act reduced competitiveness generally, as it precludes other potential investors from bidding and more competitively priced generation being made available to replace the old units needed to be removed from the grid. This thus eliminating the potential for consumers and industry to benefit from lower electricity cost. The next recommendation is from the OUR, and they indicate it is not clear whether the GPE's right to approve the power purchase agreement between the single buyer and its subsidiary under section 20, subsection 8, is in addition to the OUR's obligation to approve such agreements between the single buyer and an independent power producer. The single buyer's subsidiary would be in the position of an IPP in the scenario contemplated in section 20, subsection 8. This should be clarified, and it is recommended that the regulator's approval function in this situation be confirmed. Also, the GPE would benefit from the sector regulator's technical expertise and broad knowledge of the sector, and should be required to consult with the regulator prior to approving the exercise of JPS's right of first refusal through a subsidiary. It is recommended that the OUR's function of reviewing and approving the terms and conditions of power purchase agreements in section 19 of the Act be expressly applied to the approval of the agreement between the single buyer and its subsidiary contemplated in section 20, subsection 8 of the Act. Also, the decision to permit the exercise of JPS's ROFR through a subsidiary should be subject to the consultation with the office. So that completes the comments on section 20. Moving to section 21, description, renewable energy. The first observation from the Jamaica Chamber of Commerce. Section 21 of the Act does not sufficiently deal with the worldwide drive for greener electricity using renewable sources. There is only a cursory mention that renewable sources may be prescribed by the minister, which may be included in the feed-in tariff. And the OUR's recommendation at section 21, subsection 1, it was not believed that there should be discrimination against an acceptable generation technology by pricing. That is, the introduction of feed-in tariffs, especially in light of the experiences of other leading countries and the downward pricing trends for the various technologies. To the extent that a policy decision is taken regarding the proportion of renewable energy sources in the fuel mix, the most cost-effective option, which satisfies applicable technical requirements, should be chosen to meet energy targets. Given our local experience in renewables and the international experience with feed-in tariffs, we do not believe that there is any need for the latter.
OER is onto a good thing, and Minister, when we're rewriting the license, this has to be taken into consideration and acted on in the general direction that OER has recommended. This is in Jamaica's interest.
Minister, if I may, can the technical team...
Can't hear you very well, Senator Golden Campbell.
Are you hearing me any better now?
Much better, yes.
Yeah.
Right. I'm trying to stay mad. Can the technical team comment on the policy in relation to renewables that currently exists?
The policy targets 20% renewable in the energy mix by 2030.
Where are we now?
We're now at 11% for the overall energy mix and 13% for the electricity sector.
Good. Since we're redoing the license, sorry, go ahead. Sorry, Senator, I forgot you're on the floor.
Yeah, I just wanted to ask, and over what period of time, how long has it taken us to get to 11%?
Well, the policy was promulgated in 2009, and so that would be the period from 2009 to 2021.
And prior to that, we didn't have any appreciable amount of renewable.
Prior to that, we were at about 4% of the overall energy mix being renewable, which was mainly the hydropower and some smaller amounts of solar. And there was one Wigton wind farm facility that came on stream in 2004.
So the question then, if I could be permitted to just follow up, is we, from 2009 to now, the growth in the renewables has really only been an additional 6% to bring us to, we were at 4 before, so at 7%, sorry, to bring us to the 11% we are currently today. So in terms of this provision, is there a concept that policy, that there ought to be something a little stronger as kind of, I guess, moving in the same direction as the OUR, in the legislation to support and buttress that policy?
Yes, certainly. The OER's recommendation is quite valid and on point.
Chairman, through you, I think the numbers tell us that what we've had as a policy has been largely a disincentive, not really a strong incentive for people to go into renewable and green energy. And let's not bother argue about that. That's history. Now let us look at what's happening in the future, where the world is going and where we must go as a small island state that is exposed to all kinds of exogenous weather conditions, and how we must protect what we sell as a tourist ideal from, dirty fossil fuel, some of which we'll have to continue to use. But the policy now must be that you can't be moving from 4 to 11% in that period of time. And it goes along with the fact that we should now raise the cap from just 10 and 100 to say we must have 30 or 40 or 50 megawatts of power being given to the distributed, that is smaller persons, so that they can get involved. And also go along with the line with the OUR that really we have to change our policy completely. And I think the OUR, really quite interestingly, the OUR is onto a good thing with many of its recommendations. And we should bear those in mind as we craft this policy.
Agreed. Agreed, Senator.
So I can move to the next comment on renewable energy from WRB Energy. Their recommendation is if Jamaica is to achieve its renewable energy penetration goals, it seems prudent to revisit the structure by which customers are permitted to interconnect with the national electrical system. While generally contemplated in section 21, subsection 1 and 2, currently there are rather draconian limitations to who may interconnect and under what terms. A liberalization of these policies would open the floodgates of customer adoption of distributed generation systems. We therefore suggest consideration of the following. 1, law or regulation be enacted to remove the prohibition on the export of power from customer-owned renewable energy systems with a nameplate size greater than 10 kilowatts. 2, the system operator, JPS, should determine how much intermittency may be permitted on any given feeder or on any part of the system based on technical modeling to ensure proper operation of the national system. 3, ideally, exported power would be purchased by the operator at either a market-driven time of generation pricing, market clearing price, or B, a flat standard offer contract price to be modified from time to time. At 4, such purchased renewable power may be counted by the system operator in the achievement of its renewable energy targets / sustainable development goals. At 5, furthermore,
may I stop
sure,
at 4?
Sure.
I'm going to read that again. Such purchased renewable power may be counted by the system operator. That means JPS, is that right, Ms. Teller?
Yes, that is currently JPS.
All right, such purchased renewable power may be counted by the system operator in the achievement of its renewable energy targets, sustainable development goals. You know, that's fine, and it's good if it's in your corporate plan, but this is not the corporate plan. This is Jamaica Inc.'s plan, and it must be in the interest of Jamaica, its economy and its people. So yes, we hear what is being said here, but it must be interpreted clearly, and that's not an interpretation as a policymaker for the government that I would take as a policy for the government. That's a really good policy for a private operator.
I just want to add one clarification, member, is that the Electricity Act foresees a ring-fenced system operator. And so it is the way it's written into the act, the system operator would be independent of the JPS. So just as a note, the comment here may be looking at how it is treated in the act.
So you're revising what your answer to me was?
No, I'm saying at current, JPS is a system operator.
I see. Okay.
But the act, there is a separation in that the act is speaking to an independent system operator. So I'm just making that clear.
Thank you. We have to see how independent that is, and thank you for that clarification.
Can I continue?
Yeah, I'm done with my comment. Thank you.
Okay. All right. At item 5 of WRB Energy's recommendation, they indicate that furthermore, to liberate additional capital enabling consumers to install renewable energy generation, we suggest that the prohibition of variable rate lease purchase contracts be removed. This would enable a supplier of a system to tie the performance of the system to the benefit the customer receives in the form of energy generated.
Good suggestion for consideration. Should be considered as we look at what we're going to finalize. Who were the writers of those comments, Ms. Teller? I missed it.
WRB solar
Okay.
content.
Thank you. Yes.
Solar developer in Clarendon.
Yes, thanks.
The next comment on renewable energy comes from the Office of Utilities Regulation. Let me get to it here. At 21, subsection 2, they indicate, out of an abundance of caution, it should be indicated that the electricity from renewable sources contemplated by this clause is that generated by licensees. The system operator's obligation to take such energy as it becomes available is only applicable to that supplied by persons with a generation license. References to granting and denying access are better expressed in terms of the taking or refusal of electricity by the system operator, and so the provision should be amended accordingly. It is recommended that a redraft of section 21.2 be considered. The redraft is: the electricity generated by a licensee from renewable sources to be injected into the transmission lines or distribution lines shall be taken by the system operator when available and shall only be refused by the system operator on the ground of technical reason, which shall be communicated in writing to the licensee within 48 hours thereafter, with a copy of the reasons to the minister and the office.
Very worthy of consideration.
We move across to a comment from WRB Energy. My apologies. I lost my, no, we covered WRB. I lost my place. So we're finished with part 5. And so this next set of comments relates to part 6 of the Act, transmission, distribution, and supply activities.
It's 5 minutes to 12, Mr. Chairman. Should we start this section for 5 minutes?
Absolutely, correct.
Maybe we should just close here.
You preempted me, absolutely. It's perfect time to stop because we would have completed and start fresh with the next, at the next meeting. Ms. McCarthy, what are the proposed meeting?
For the rest of October, sir, the 28th of October is the next date, based on indications from Ms. Reed for yourself. Are you hearing me?
Yes, October 28th.
Yes, sir.
What time? What time?
At 10 a.m.
10 a.m. Members, October 28th. Anybody have a problem with that date?
Right now, I may be out of the country, minister in a faraway place, but if it has to go on, it has to go on. I'm going to get the papers anyway, and if I have comments on section 6 and any of the ones up to 5 which are going to be sent to me, then I will try and get them into the operators of this virtual meeting so that I can record them if I
Sure.
can. All right. So,
Sure.
but we should go ahead. We've been taking some time on this, so we should go ahead with it.
All right, members, October 28th at 10 a.m.
Yeah, it works for me. Yes.
All right, so we can
That's
confirm.
fine, Chair.
We can confirm that.
Yes, sorry, Chair, but just to say, Mr. Lowe, we left off a number of proposals from the second document. So we might have to go back over some of the sections that we passed about the next meeting. Part 2.
Yes, yes.
It's from Jamaica Energy Partners and Newton. So
Right. My apologies. I should have been scrolling down. So we could start with that at the next meeting.
Okay.
Absolutely. All right, members, thank you, support staff, and of course, SG and others. Thanks very much.
I'm sorry, Chair, just before you go, the National Energy Policy of the Ministry, is that available on your website? Was it on your website? Is the current policy?
Should be, Mr. Lowe.
Yes, that is what I understand, and I will double check it as soon as I'm off this meeting.
Thank you, Ms. Fuller. If it is not the same thing, would you be kind enough to send me a copy of the current policy, please?
I could send it to Ms. McCarthy and then she could distribute it. I think that would be the best approach.
Thank you, Chair.
Thank you, Chairman.
Thank you, members, for another productive meeting, just short of 2 hours. And we will see 28th of October at 10 a.m. Until then, keep safe and be good. God bless.
Okay.
How will policymakers and civil society fix the fractures across the world for our benefit? Will our leaders' coordinated advocacy at UNCTAD 15 make it better for each of us? Join the conversation on From Inequality and Vulnerability to Prosperity for All with Prime Minister of Barbados, the Honorable Mia Amor-Motley, Ambassador Gail Mathurin, Director General of the Office of Trade Negotiations with the CARICOM Secretariat, Isabelle Durand, Deputy Secretary General UNCTAD, and Dr. Patrick Njoroge, Governor of the Central Bank of Kenya. They will answer your questions on the next Central Bank of Barbados Caribbean Economic Forum on the outcomes of UNCTAD 15. I'm your host, David Ellis, inviting you to join the conversation Thursday, October 7th at 8 p.m. Barbados time, 7 p.m. in Jamaica. Tune in.
As an inner city youth, I'm a duty to know the laws and my rights. These laws affect all our self-interest and safety.
The law says throwing garbage in public places or on